Yeah.
My daughter won the bracket in my house. I was a big fat loser, but whatever.
I don't know about brackets, but I know that three-pointer that guy hit from the baseline just broke our backs, sent it to overtime.
All right. Shall we jump in? What do you think?
Yeah, I'm ready to roll.
All right. So the purpose of this gathering is that the idea came up earlier that as consultants, we have this whole library of knowledge. Each of us has some knowledge, and
library.
Have a
library
knowledge. So that we're going to ask people periodically to put on a series of kind of informal seminars. We're going to ask people to pass on their knowledge, and that would mean not just to people juniors, but to anybody who could know more about a particular topic. So today's seminar is going to welcome Julie and Stanley, and they're going to pass on their knowledge and experience here about witness preparation, witness communication training. There's also written documents that are now spilling into this share file site. So it's going to be on a full range of topics. So the whole point being to put you in a position to know a little bit more about something you might get asked to do that you might be new at or just not know a lot about. So your time will come to share as well. So that's our mission. And I think I'll just turn it over. Julie, do you want to jump in first?
Sure. I'll sort of intro the topic here. So first of all, we all have our firsts, right? We have our first jury selection, our first moderated group, our first witness prep. So sometimes it's nice to just talk to some folks who've done it several times, you know, over the course of their career, and have some documents to refer to. Yeah, Dave.
Can I ask Hillary just to hit record? I just want to record this awesome intro.
I'm way ahead of you, Dave.
Thank you. Bye.
Oh, good. I don't have to repeat myself. So anyway, it's really, as Hillary mentioned, super informal. Ask any questions. I'm okay if Stanley's okay, if people want to ask as we go along, if you need clarification on something. And the other thing I want to say, and I think Stanley will back me up on this, is that there's no set way to do things in this business, right? Everybody develops their own rhythm and their own, you know, sets of things they like to do and things that they never do. And so this is not meant to be, you know, you have to do it this way, blah, blah, blah. But this is what's worked for us over the course of our careers and the styles that we've developed. Stanley and I have talked, we have similar philosophies on this and approach it in similar ways. You know, although some of our details might be different. For example, Stanley likes a flip chart. I don't use a flip chart. But anyway, so I'll kick off the first section that I spend a lot of time with when I first meet with a witness is the assessment phase. Oftentimes we're called to, you know, oh, we need this witness prep for trial or whatever, you know, and the attorney likes to always pinpoint what they think is wrong. And it's usually a substantive issue, right? Like they testified poorly in their deposition on something, therefore we need your help spinning that. That's in my experience, a very small part of the problem. But that's usually when we get the call, so we go in. So the first little bit of time I spend assessing the witness, and that is really kind of the question and answer, getting to know you phase. And in part, it's used to develop trust and rapport with the witness, because obviously, if I'm going to tell somebody that they're going to come across poorly, or even down to things like they need to change the way they dress, they're going to have to really trust us and have a level of confidence that we're on their side, even when we're delivering things that might be uncomfortable. So the assessment period is building rapport, building a trust, and also I like to see how dexterous this person is verbally. Are they going to be able to do some of the things required to get good testimony across? Or are they the type of person who really has to be guided into answering, you know, very narrowly? Or are they alternatively somebody who can really talk their way out of a potentially tricky situation? So that's also part of it. I'm looking at their level of anxiety. Stanley, jump in anytime too. Highly anxious people aren't good testifiers, and most everybody is anxious about testifying. So it's really important to see how anxious they are and where that comes from. That part's really critical. A lot of times I meet with a witness and they don't even know what the claims in the lawsuit are. So they might be, you know, the attorney might say, oh, they're only going to be on the stand a couple hours, and you get somebody in and they don't know what the case is even about. So if they don't know their role in the case, then they get really nervous about, what if I say the wrong thing? What if I don't know the answer? I don't know what they want from me. So all of that inhibits someone's, you know, testimony and how they come across. So I spend, if it's a half a day and the witness, I guess, is fairly run-of-the-mill anxiety-wise, this might take about half an hour, 45 minutes.
Okay.
Yeah, go ahead, Stanley.
Yeah, I will just tag team on that a little bit as far as the intro, or the breaking the ice is what I call it, getting to know you. You know, this witness, well, a long time ago, I decided to kind of set myself apart from the attorney who's prepping the witness. And so I will more likely than not refer to it as training. And I don't know, I feel like I've got a buy-in from the witness when they think that they learn to believe, because I am sincere, that I'm there to help them be the best witness that they can be for themselves. And that the attorney is going to prepare them for their substantive part of their testimony. And so I like to try to, you know, keep myself, here's the thing with this witness training deal. You know, it's as much art as it is science. And you can only learn by doing. You can only get better at it by failing. And I tell you what I did. I mean, Hillary can probably vouch for this. You know, there's a lot of stuff that they don't teach you in law school, okay? I don't remember a whole lot of time being spent on preparing witnesses for deposition or trial testimony. Sure, I'm sure they talked about it, but what it usually evolves is, hey, you know, why don't you come to my office, you know, maybe the day before or a couple of hours before your deposition, and, you know, I'll give you some do's and don'ts, and we'll go over some documents, and then you just throw them in the deep end. Well, I probably was guilty of preparing witnesses that way when I first started practicing law, but it didn't take long before I found out that I was doing it wrong and I could do it better. And then when I started consulting about 20 years ago, I really had an eye-opener, because then I started getting to talk to more and more jurors. And in our business, because of, you know, alternative dispute resolution, we get to talk to, listen to, watch, interact with more jurors than attorneys ever do. Okay, maybe in 1 year we talk to more jurors than some lawyers will do in a lifetime, or 5 or 6 years. So what I decided early on when I started eye opener was that, hey, I needed to go from the camera out. I need to go from the jury box out and listen to what the needs and expectations that jurors have for witness testimony. And so then I started helping develop a protocol that focused on that. And again, Julie touched on this, you know, it's more, well, if I had a graphic that showed substance and performance, okay, substance would be a little bitty down here and performance would be way up here. And I know that you'll all vouch for that if you've ever done any post-trial debriefing where you talk to jurors about the case and talk to the jurors about specific witnesses, and you mention a witness and they can't remember the name. You have to describe the witness. Oh, okay, I got it. The first thing out of their mouth is a positive or negative, okay? If it's a positive, it's usually, oh, I really liked her. I really liked him. Then if you followed up by asking, well, what was the takeaway from that particular witness that you liked that influenced the way you solved this case? And you wouldn't, 99 times out of 10, there's a big pregnant pause, and they say, ooh, wow, man, I know that, I just know I liked them, okay? So that taught me a valuable lesson that let's work on demeanor, let's work on confidence, let's work on listening skills. Let's help this individual make a connection either through the camera to the jury or to the jury in the jury box, that they will accept that person as someone that they believe in. They believe them, they trust them, they like them, and then you've gone a long way. as far as the introduction, I like to call breaking the ice. People like to be included. And, you know, I'm no psychologist, but I learned a long time ago when I was a kid on the sandlot, you know, standing on the sidelines and, oh, hope they pick me, because it's so embarrassing if you don't, you know. So people like to be included. I like to find out, you know, a little bit about the person. You know, what is their support system? Or are they married? They have children? Where'd they go to school? You know, what's their favorite team? What do they like to do? And by doing that, having that conversation, as Julie was saying, you're making assessments all the time. You know, is this person like half answering? Or are they like, you know, what does this guy really want to know all this stuff for? Or what does it have to do with anything? Or, you know, but the main thing is I'm trying to make a connection, just like an attorney would try to be making a connection with the jury panel and voir dire, that we can move forward from that. So that's my my kind of ice breaking thing. And another
question, real quick.
Yeah, Eric.
Yeah, I just want to jump in real quick. So when you're doing this, I mean, well, I guess it's kind of a twofold question, right? Do you still find it best to do it with the attorneys present, or do you try to build this rapport while they're not there? And is there an issue of meeting with a witness without attorneys present?
Okay, that's a whole nother deal. Yeah, that's a whole nother deal. And you still get, even in this day and age where we probably none of it, Julie, I haven't been drilled down on a long, long time about, you know, who did you meet with? How many times did you meet? Was there a consultant present? You know, that is a bugaboo that attorneys have. You know, the case law is such that, yeah, you got to tell them certain things, but there's a line drawn in the sand, and the federal courts have come on it as attorney work product. But I always want an attorney there. Now, where the question comes in is, who do you want there, and how many do you want there? And I'll give you a brief war story on my recent deal with
Well, hold on one second, Stanley. I just want to answer really clearly for Eric. You should always have an attorney present for your own sort of protection in terms of everything being protected. That doesn't mean if the attorney steps out of the room, you can't talk like sports teams or something with this person, but any substantive prep. It also doesn't have to be an attorney on the team. One of the things we run into is, oh, I don't have time to prep. I'm so busy doing other things. Just get any licensed attorney from the firm to sit in there and you're protected. But so
right,
that's the short answer.
We have observers on who are not attorneys and who are not necessarily jury consultants. So for their benefit, the idea being big concern for attorneys is keeping the privilege between the witness. We don't want any breach of confidentiality, and they're concerned about having us direct and alone with witness that comes from.
So great question, Eric. So the answer is yes, you should always. And so go ahead, Sam.
Some attorneys have a problem even with you doing it at all because of this fear that they're going to be discovered. Well, okay, what can they discover? Well, that someone was telling them to tell the truth. I mean, you know, we've asked this question to thousands of jurors after the fact, and it's really no big deal to them, and it's cured by motion in limine because it's not evidence. Okay, maybe curious, but it's not. It doesn't go there. But that's another whole thing as far as Eric. You know, who's in the room really matters only if that person in the room interferes with the preparation. Okay, and here's the situation down in Laredo. I've got, and the client wanted these 3 attorneys there. Okay, well, we've got Mexican-American fact witnesses who are very vulnerable. They don't know why they've been pitched in this thing, where their name came up. And within about 20 minutes, it was like a machine gun attack from each other attorney tag team. And it says, well, you need to be aware of this. Okay, this might happen. And I call the client at intermission saying, hey, I'm just taking your money because I'm not being allowed to train your witness. So there's all kinds of nuances, Eric. And you can only find out by doing it. Okay.
Yeah, I mean, sometimes there'll be several attorneys in the room. Sometimes there'll just be the one who is, quote, taking the witness. That's not a great idea either. But we can get to that in a little deeper when we get to sort of some other sections. So, you know, just to kind of underscore the assessment period, I think it's one of the most important parts of witness prep, because I don't know how you can make your action plan if you don't know what kind of witness this might be. And sometimes you haven't had a chance to review the deposition in its entirety. You've never seen this person's clip. I mean, sometimes you get called in and they're like, oh, here's, you know, Susie Q, and she's this person in the company and she's going to testify about X. And so you need to spend some time to decide what your next steps are with this person.
many times the witness doesn't even know, Eric, or the rest of you, why they are the one there. They don't, and Julie touched on something very important as far as, what are the claims? In this recent case I've had, none of the witnesses had even been told what the plaintiff's claims were. So I used a flip chart right away, and I said, look, this is the party platform. And I just try to bullet point them very simply. One, plaintiff is saying electric company didn't have something there that should have saved this guy's life. Two, what they had there didn't work. Three, failure to inspect. Four, X. And if they know where the snakes are under the rocks, you got a chance to help them, deal with those problems. But just, let them come in just totally ignorant of why they're there, where do they fit in the case, is solved by that early assessment, early discussion.
Yeah. And then in terms of anxiety, you're going to find a lot of witnesses have more, or some witnesses have more than others, and it comes from different places. I recently had a witness who had total control issues, and it was really inhibiting her ability to answer a question that appeared to be a straight answer. And so as I was talking to her, it became clear that she was never, for example, this sounds weird, but she was never validated as a child in her family unit. And she was so concerned about how she was coming across that she used language that was unclear. So she would say things like, well, I conveyed to the people I was talking to, and that just at the end of the day, that sounds evasive if you can't just give a straight answer. And she just was so adverse to being judged by anybody. She was very fearful of that. So things like that can really help when you understand why somebody's doing something. So that's really the critical component of sort of breaking them down and deconstructing, like what's the one question I like to ask is like, what is the worst possible outcome personally about you testifying? What's the worst thing that could happen? And some people, I've had a witness cry and be like, I just don't want to do this. I'm so scared. I don't know. I might lose my job. Blah, blah, blah. They just have no context to this whole testifying thing. Now, experts are a little different, and maybe we have to do a separate expert witness thing. But in general, the fact witnesses that may not know why they are called because they have a very narrow role in the case, that's just general anxiety about, I don't know what I'm supposed to say and do and why I'm here. And anyway.
Where do those skills come from to be able to, you're almost psychoanalyzing people a little bit in real time and kind of making your conclusion, when you say they have, issues from a child, how it's got to take a while to get to that point where you get that information.
Sometimes it can. That's why I like to spend, half hour, 45 minutes. Sometimes it's really obvious. Sometimes you'll never get there because they're not willing to sort of concede anything, but you can see that something is there. And it's not, like, oh, tell me about your childhood necessarily, but sometimes the issue is pretty obvious and you can just take a few questions to get there.
Yeah, especially it becomes real obvious when you're just trying to introduce yourself, not necessarily credential while you're there, but just to break down a few communication barriers so that you can move forward with, with a little bit of trust. And a doctor I had in New Jersey, I'm kind of feeling him out, like, what's his background, where'd he go to school? His first words out of his mouth, why is this necessary? Well, right away, you know what you're dealing with because he's going to be an arrogant SOB that you're just going to have to, kind of go through the day and hope that something you say clicks, that he decides on his own that, hey, maybe I should, listen a little bit. This guy's got something worthwhile to teach me, okay? So it all depends.
Yeah.
With respect
to not every witness is receptive to this. So some witnesses are just going to be bad and you do what you can, but a lot of them really want to do the best that they can do up there. It only helps them personally.
Right. And too many, like this situation where I had, and this was the first session with the witness, they brought me back a week later to maybe, after the client learned what happened, and the witness was there early, Juan Vasquez, and I talked to him by himself and I said, well, how do you feel today from what we did last week? And he said, I haven't slept in a week. So this witness was already ruined by the attorneys just jumping in and just beating him down to the point where he was just a basket case. Okay. But that's not you can only deal with that if the client will let you deal with it.
Yeah. And as part of the assessment, that's why it's really critical to build trust, because you have the witness has to believe that you're on their side and you want to help them, and part of helping them is understanding what the problem is, and so then they tend to open up a little bit more. But that takes a little bit. It's not going to happen in 5 minutes. And it's not going to happen, to Eric's point, if there's a lot of attorneys in there who want to skip right ahead to the, faux cross exam. I mean, that's why, Stanley sent an agenda out ahead of time, kind of setting the stage and saying, look, if we're going to do an effective witness preparation, this is the time I need to do what I'm going to do. Right.
That's very important. And one thing that I see right now we may need to address in the future, Dave, is the scheduling, the timing, and Julie will vouch for this. Deposition training, well as any witness preparation that a consultant does, needs to be timed correctly so that the training will take. You can always have refreshers. Too far out and it's gone, too close and it's like, this too much. And so what I'm seeing is that in this new case that came up is, the salesperson is scheduling the things before the consultant even has had any interaction with the attorney to see what the witness needs as far as half day, full day, that sort of thing. So anyway, that's another discussion.
Yeah, I will just add that the half day sort of has evolved from, an 8-hour day or a 7-hour day with one witness can be really exhausting for them. So a half day is great if you have another half day the next day and they can kind of rest on it. But I wouldn't be afraid to say, look, we need a full day, and if we have to take a 2-hour break, we'll take a 2-hour break. But many witnesses, once they sleep on it and they, the next day is more productive. So for example, Stanley, I got Karen Perry on Saturday. She doesn't work for the county anymore, so they had to hunt her down and serve her. I got one afternoon with her. That's it. So that's sometimes what you get. It just depends. But
yeah, one afternoon is better than no afternoon.
That's right.
So with that, Stanley, just to wrap up that comment, would you suggest that if you can't get a call and people are just looking to get a price and an idea of what this process calls, that you'd say we really would prefer a full day, 2 4-hour sessions separated are the best opportunity?
Right. Well, usually what I prefer if I have the discussion with the attorney before it's scheduled is, look, I'm going to send you a flexible agenda depending on what time you have, what time the witnesses has available. I really don't like to put a time period on it. And if some witnesses are good in 3 hours, some are not going to be good if you spend 3 days. But if I'm there to do a full day schedule, that means that, like Julie said, that doesn't mean that we're just pounding for 8 hours. It's no good. You got to smell the roses along the way. If you've got some teaching video of some prior deposition clips, somebody being arrogant, somebody, volunteering information, you can do a show and tell. You can go to lunch. You can step out of the office and
and I think flexibility is key, because if your first assessment period shows all kinds of landmines, you're going to maybe need some time. So setting these things up, to be flexible, I like to do 2 days with the client because that allows you to be there the next morning if you need to or whatever. But again, we're running into the issue of clients do not want to spend 2 days sitting in a room with witnesses. And so it's really important that we say, look, we just need an attorney. It doesn't have to be you.
Right. You just need a baby attorney. I think that's coming from the attorneys back to the client. Once the client, if the client ever is there personally and observes the training, or they see the results of the training, then they get on board. And then I've had, John Stewart with Encore Electric Delivery. He showed up at the deal and training, and he could see that right away that the attorney was not going to let me do what he wanted me to do. So I stepped out of the room, and John brought me back in, and he says, okay, I want you to hear this. And he told the attorney, look, I'm going to take the file. This works. You're going to let this guy do it without interruption. He's going to have some time there for you to weigh in on objectives, put more on his plate, on the witness plate, take some off. But they've got to allow you to do the training that will work. So that's just another nuance you have to deal with.
Yeah, and that comes with experience too. I've worked with a witness and the attorney was just like Stanley's described, didn't want to let me do whatever I did, and then turned around and complained that witness prep was useless. So you get all kinds. So I would say the next phase in my little world of witness prep.
I have a quick question, if you don't mind.
Sure. Yeah, Denise.
So if you have a pre-call with the attorney, is that where you're getting the information as to how long you think you're going to need with each witness?
Well, first question is when is the deposition scheduled? If it's scheduled, when is the trial? When does he expect this witness to testify at trial? Then you look at dates to conform with that, okay? So you got to know, it's like this first deal with the AEP, it was like 10, 15, 20 days before the deposition, and that's basically, you got to have a refresher after that. So
right.
Timing is.
So how long? So how long in advance would you not request or like ask to have a refresher? If it's like 2 weeks in advance, then you would need a refresher a day or two before, or if it's a month, or how? That's
hard to answer. It really depends on the witness, but a refresher is never bad. But if you're talking about deposition and you only have one shot, 2 to 3 days before the deposition is okay. 4 to 5, 6 days is maybe, you're losing ground there. Okay.
Okay.
Man, if we can get in before the depo, that would be really great. But I would say, as a general rule, if somebody says we have 2 witnesses for you, I want 2 full days, and then we can revisit somebody the next day or whatever. I mean, I think trying to cram 2 witnesses into 1 day and that's all they want.
Yeah, Julie, how do you feel about Witness University, where you've got what client wants to tag team and bring 4 or 5, 3 in one session?
Yeah, I did 6 witnesses in 1 day a couple weeks ago.
Well,
what am I going to do? It was just that was their time frame. That was the only 2 days they would allow witness prep, and they had a long list of people. Some people that was okay. Others clearly needed more work, and then it settled.
Well, preferably each witness has unique challenges, and what's good for one is not good for the other. When you give some training to one, and the next sucker takes the whole bottle of aspirin. So one-on-one is always better.
Yeah. But again, flexibility is key for sales, to just say, look, let's budget X 2 days, but somebody could need a refresher.
Yeah, when I send out this agenda, that's exactly what I tell them. This is a very flexible agenda. Things happen interim, so we're just kind of a guideline, but these are the areas that I need to touch on. I like to have, I like to have 2 practice sessions segmented in between with training.
Okay, thank you.
Any other questions? And I just want to add that I am upfront with people about what I do and, what I'm not. I'm not a psychologist. I'm not there to do, I'm just a communications person, but I want to help them, get their message out.
Yeah. And a short credentialing is not bad if, what I tell folks that I'm working with is, look, for over a period of years, I found something that works, that's based upon the needs and expectations jurors have for witnesses. And because of that, I can tell you that the training that you're going to get will help you meet those needs and expectations.
Yeah. Yeah. And it softens the blow a little bit if you say, look, this is what we've learned from jurors. Like when I have to tell Karen Perry to look a little softer, it's coming from jurors, it's not coming necessarily from me.
Mm-hmm.
Okay. So the next thing I do is sort of what the action plan is. So that stems from or flows from how good or bad or how much work a witness might need, or how confident you are that he or she can catch on pretty quickly. So the action plan is working with the witness to say, look, these are the areas we want to cover. I'm going to be looking for your tics, or, whatever it is you've seen in your assessment. They might say, a lot, or, and, those are things you can say, look, these are the heads up. I'm going to be stopping you as we go along in some cases. Other cases, we're going to record you and play it back, all of that kind of stuff. So that's sort of for me, a little bit of a shorter part. And usually that's where the attorney jumps in and we start talking about areas of testimony that are critical, and we go over what their role is and how they fit into this case, and generally kind of what the claims are and how they can help.
Yeah, I do it a little, it's basically the same, but what I try to do is early on, I talk to the witness about, and I usually use the flip chart and I draw a box and I say, okay, down here is the stuff this is the substance of your testimony. I'm going to talk about three concepts, whether you call them targets, your borders, your frame, and your persona, your conduct and character. When I talk to a witness about his targets or his objectives or testimony, I like for the witness to describe to me what they feel that they would like a fact finder to take away from what they said, okay? In other words, a lot of times the attorneys don't have this discussion with witnesses and they don't have a clue what really the bases that they need to touch or the mail they need to deliver. So you start that conversation and then the attorney can say, well, another objective for your testimony will be X. So you can bullet those out on a flip chart, and if you have a refresher, you can tear that off and save it for trial, because those are really the safe harbors, okay? It's just competing objectives. Plaintiffs are coming with the objectives for this witness's deposition testimony, trial testimony, and on the other side of the coin is our objectives on how to handle those things. And one way of asking it is, what are the problem areas where if you're coming to poke holes in your testimony, where would you start, or where's the weakest part? And so by getting the witness to buy in to, look, I'm just responsible for these things, then you've already defined what's on their plate and what's not.
Right, and sometimes a witness might say, for example, well, I'm in charge of sort of compliance in X, Y, and Z area, and then you say, okay, well, what questions do you not want somebody to ask you? And
Right.
then you can find out sort of what they're worried about, because so often the attorney just wants to launch into like the Q&A, and the witness is not expecting, wasn't prepped on what to expect and can't answer the question. So that's why it's problematic when you don't prep before a depo, because they don't know
They don't know why they're there.
coming at them and how it all fits together. So that sort of action plan, what Stanley was talking about, is like, look, this is how you fit in. This is how we're going to practice it. And of course, underlying all this is that we want them to tell the truth. That's obviously that's the number one rule.
Mm-hmm.
But getting them comfortable with the subject matter, the scope, and what's going to happen. Also included in this is I talk a lot about what to expect when they testify, the difference between depositions and trial, tricks that the opposing counsel will use, that kind of thing. That's where I put that stuff in this little section too.
Yeah, and part of that, my action plan as I start, I kind of tell them, what the flow is, okay? And one of my early things that I talk to them about is if they take away nothing other than these four things. One, tell the truth. No one, if the attorneys, and if you get there first before the attorneys can get there, you've already established the fact that, telling the truth just relieves them from a tremendous burden. Tell the truth, kill with kindness, talk to your attorney. Anything comes up, a question you have between now and the time you testify, I don't care what time of day or night, get it resolved. And number 4, how do you answer this question? What did you do to prepare for your testimony? And that should always be a short, non-argumentative, met with the attorneys, review documents, anything else. That's it. So I get that out of the way right off the bat so that they will know that, look, this is something that I can do. This person is going to help me be a successful witness, and you're off and running.
Yeah, and another thing that I find with fact witnesses is a lot of them have never testified in court before, even if they've given a deposition. So I run through very basic things like, okay, they're going to call your name. You got to walk all the way up to the witness stand. It's nerve-wracking. Everybody's staring at you. It's completely uncomfortable. They're going to ask you to raise your right hand. Even basic information like that, they don't know. No one has ever told them, and it can throw somebody's testimony off if they weren't expecting it. So again, this is the time, like Stanley said, you're going through all the basics, the bottom line. This is what you can expect, moving forward.
Right. Yeah. One way I approach it is, look, my job is here. Let's say we're talking about deposition training, is take away this mystique of giving a deposition testimony. And I one time had a graphic that I put out there, and I like to do it again sometime, is what is a deposition? You ask the witness, what do you think a deposition is? Well, usually they don't know if it's just an entry-level fact witness. So, I give them the legal definition, process, under oath, use of discovery, blah, 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 for possible later use at trial. Then I put up the real world definition, okay? It's an opportunity for plaintiff's counsel to get a unprepared witness or an unfocused witness to, give testimony that is not accurate, or get, capture these sound bites. Also is to evaluate the witness's vulnerabilities for later use at trial. So I tell them that my job is to take away that mystique of giving testimony at deposition. It's a one-day job, just like the job they learn, to do their job. If somebody tells them, what to expect, what are the nuts and bolts? What happens there? Why does it happen? What can I expect? If you just strip away all that, you build confidence right away.
That's right. And it releases a lot of that anxiety, because there are significant differences between depositions and trial testimony. And, a lot of fact witnesses don't even know, if somebody objects during a deposition, they don't know what that means. They fall into the trap thinking opposing counsel is their best friend, and, they're starting to chuckle with them. And, it's just all this stuff they need to know. I mean, it's really about empowering them, to not be afraid and to give their best testimony and put their best foot forward. So you were laughing, Stanley, about. Yeah,
just to give them as much information about the basics as you can. I had a clip at one time of a celebrity, Jack Nicklaus, in an intellectual, it was a trademark infringement case. And his attorneys did him a real disservice. First of all, they couldn't get past the celebrity to tell him what he needed to do, or how he needed to act, or what he needed to wear. They didn't tell him anything about what objections meant. He's on camera, questions asked, attorney says objection form, and Mr. Nicklaus looks over like, well, what did I do wrong? Okay. Yeah. So, it's just amazing what goes untaught to these witnesses, so anyway, that's where you can shine, and really that witness is very appreciative of the information that you're giving them, so that they can, not be surprised by things when they get there.
Mm-hmm. It's very uncomfortable. I also go through, like I mentioned, the difference between deposition questioning and what might happen at trial. Also at trial, how their attorney will rehab them, which doesn't happen in a deposition. So there's all kinds of technical things we have to know about how a trial operates before we go in as well. But it's all designed to kind of put them at ease, make them more comfortable.
Yeah, even the fact that I've noticed that our attorneys often fail to tell the witness that they can be called in the plaintiff's case, okay? Mm-hmm. So they can start off with cross-examination questions, narrowing their escape route. So, letting them know that, this deposition testimony could be used at trial. It's normally used as an impeachment vehicle, where they've got a kind of a back pocket gotcha. If your deposition testimony is, is inconsistent with your trial testimony, then they don't care what the answer is. They just want to show you up in front of the jury as being, not less than credible.
And here's where you can also talk through some of the common problems, when a witness, for example, is really relaxed on direct and really uptight on cross. There's nothing that jurors notice more than that. Or they're really scripted. We want to stay away from scripting a witness. You never want them to be scripted, which is, attorneys like to say, here's your deposition, memorize this before you go to trial. That's not the way to do it.
I know, and that's one of the things that I try to get out there early on before actually the attorney actually gets involved in the things. And I tell them, look, this is what witness training is, or witness preparation is, what it's not. We're not here to make you over. You have to be, confident in your own skin. You won't be scripted. You won't be given lines to remember, because a scripted witness is a dead giveaway. And hopefully that will cut that out. Sometimes it doesn't. These last 2 AEP sessions I've got an outside counsel who's been working with for 25 years. And so you're hardly going to get past that. But about every 5 minutes, the attorney would say, well, you need to say, this is how you need to answer. You need to say that my intuition tells me that this thing would not have, well, I'm sorry, this Mexican-American is not going to say my intuition tells me any damn thing, okay? So it's scripting doesn't work. And we've all seen scripted witnesses. It's a dead giveaway. It's a staccato delivery. Their eyes are looking around the room for lines. I had a great clip of Oprah Winfrey one time where she's, given an answer by Chip Babcock, and she delivers the answer, and it's like totally unlike how she extemporaneously talks on camera, okay? So scripted witness is a dead giveaway, and jurors say obviously coached. Okay?
Yeah, and so that goes in the bad category. One thing I wanted to cover, and I probably should have said it earlier, is that there's this myth going around that that your witness that jurors don't have to like your witness, and I want to tell you that that's not true. They do have to like your witness, because if you think about people in your own circle of friends and your own circle of life, who are you going to trust? You're going to listen to and trust the people you like. You will dismiss the people that you don't like for whatever reason, whether it's a visceral don't like, whether they're scripted, whether whatever. So, and Stanley and I have talked about this, and it's one of a hurdle we have with the lawyers and other people to say, well, it doesn't matter if they like you, it matters. And so that's all part of our training, is we help the witness become warm and engaging and self-deprecating to a certain extent, and just like a human being that puts their pants on one leg at a time, right?
Here's how I like. Is that somebody? Well, here's how I like to do it, and Julie's right on. In fact, when I looked at Magna's first witness training presentation, and it had that myth up there, I'm saying, golly, you know, I'm not saying that they got to love you, but they dang sure can't dislike you, okay? And so I don't tell the witness that they need to be likable. I set a segment aside for the area I call conduct and character or persona. And I tell the witness that of the hundreds and hundreds or thousands of jurors I've talked to about witness testimony, I always ask them to fill in this blank. I thought Mr. Jones as a witness was blank. So then I asked the witness to fill in that blank for herself. You tell us what you would like for a juror who's seen your deposition clip, who's seen you testify at trial. What adverb, what attribute would you have them put in there? And they start, and they'll, you know, well, they might give you one or two, and then they get stymied. And I'll say, I'll tell you what, after a while, I'll say, I'm going to give you number one. And number one is likable, because every time I talk to jurors, the first thing, if it's a positive, I really like them. And I just didn't stop there. I asked jurors, well, what do you mean by that? What are you saying you like them? You haven't had a conversation with them, never had a cup of coffee. So what they're telling us, and I tell this to the witness, is that just like your friends, okay? I'm not talking about people you know. Those are acquaintances. I'm talking about your friends. You like your friends because, first of all, you trust them. You trust them with the information you give them. They trust you with the information you know about them. So it's a trust thing. They're looking for someone like them. And the way I like to describe it is that if you were sitting in the witness box, and you're looking at the jury, and there's an empty chair in the middle of that jury box, if you were to get up and walk around there, they wouldn't duck their heads down like on an airplane where, oh, please don't sit next to me, you big sucker. They would say, okay, yeah, here's a place for you, okay? They're looking for someone that they can relate to and say, you know, he wouldn't be a bad person to work for. Well, she would be a good neighbor. So that's what the likability deal is all about. Yeah, and it's really doubly hard when you're a witness for the defense, especially if you're called adverse in the plaintiff's case. I mean, jurors are looking for reasons not to like you and trust you as a witness. So, you know, all that, again, is part of the education process about what jurors are looking for and why they're in a difficult position and why it's really more important to work with these people. Mm-hmm. I like to say demeanor is character. And, you know, jurors are looking, well, the reason that they give you these attributes, they tell you about what their ideal witnesses are. You can tell the juror, you know, okay, I mean, your witness, okay, understandable, okay? Juror can't retain what they don't understand. So you have to make it, what you say to them, understandable. You know, you got to keep your jargon at a minimum, or you got to at least help them understand what the jargon means. Professional, sincere, forthright, confident, calm. You know, calmness equates to credibility. Consistency, as Julie mentioned before, that consistency is key. Expert witness, South Texas mechanical engineer on direct examination. Oh, he was all direct as, you know, just sweetness and light. I talked to the shadow jurors, the mirror jurors that night, what they thought about him. You know, he's always moving intelligent. I really liked him. Very smart. Next day on cross-examination, he fought on every question, every throwaway question. So I talked to the shadow jurors that night. What do you think now? No sit. Él tiene dos caras. He's two-faced, okay? So once they see that inconsistency, they're challenged. Who is this person really? So if it's important that them to understand and retain what you say and act on it, then you can't be inconsistent, because then they just dump the whole thing. Okay.
Right. Which I think is a great segue into sort of the last part of witness prep, which is the Q&A practice, which doesn't mean that it's insignificant, because it's not. It's just sort of the how you end sort of most of your sessions. One of the problems that we run into is the attorneys sometimes this is the first time the attorneys are meeting with the witnesses too. So they want to spend all kinds of time telling the witness how smart they are and how they have the case figured out and blah, blah, blah. And they neglect the practice part, which is really, really critical. You know, sometimes I videotape, sometimes I don't, but I like to start off with cross if they're going to be called as a hostile witness, or I like to start out on direct if they're just going to be a regular defense witness. Playback if you notice anything. But one of the really critical parts of this is to set the attorney's expectation that, you know, with this, whatever witness, you need at least, quote, 20 to 30 minutes of uninterrupted Q&A to kind of walk them through it, or you'd like to stop as you see things to go along. The other critical part is almost every time the attorney underestimates and underplays cross-examination. And if you want a witness to shit the bed, you want them to do it in practice, not on the stand or not in the deposition. So the cross has to be tough and tougher than what you might expect at trial. And some opposing counsel, you know, they really hit the witnesses hard and some don't. But you don't want to find that out in the deposition or on the stand. So, and I think Stanley does this too, we recommend that the attorney that's not in charge of the case or in charge of this witness, we recommend somebody else do the cross that they don't have a relationship with, because that person will not be afraid to ask the hard questions.
Yeah, I agree. And if you look at my agenda, I like to start the Q&A, and I like to have it very shorter than longer, 15, 20 minutes max. And I like to do a little, you know, introduction, assessment, kind of basic rules, and then, you know, let them start, and then we can critique if we have time. But, you know, I like to do it 15, 20 minutes. I like to video it. I've got a little camera. I click on my deal, and I play the video back, and I tell everybody, look, we're gonna get through the Q&A without interruption, okay? And sometimes that's hard, because in this last deal, every 2 seconds, the attorney said, well, here's how you need to answer that. Well, it's just not going to work that way. Anyway, but what Julie says about who does the Q&A is crucial. Just, you know, that relationship between the attorney and the witness is tenuous, you know, and that really needs to be a trust relationship. And half the time the witness is thinking, you know, John really thinks I'm going to screw this up, you know, or I got to do good for John, you know. So if you can, you know, get the witness to understand that you're there to help them be a good witness, that the attorney that is going to cross-examine you or ask you these tough questions should not be that attorney that is going to handle you at trial, okay? Because that relationship just needs to stay intact. A lot of times I'll just say, give me the script, give me the Q&A deals. If I have enough time to learn the case, I can do it, okay? I mean, I can. Yeah,
it just sort of depends on how much time you have.
Right.
Yeah. Yeah, so again, there's lots of different ways to do this part. If I have a witness who has a tic or some physical thing that's impeding, I will stop them every time I see it, because it trains them to try to recognize when they're doing it themselves. But if I don't have any of those, I'll go, you know, 15, 20, 30 minutes, depending on, you know, what type of case. So it all just sort of, again, depends on your witness and what your witness might need and what you're comfortable with.
What's good, one of the beauties, or to me, one of the advantages of the video is that, and when we go to play the video back, I just say, look, anybody, including the witness, can say, let's stop there a minute. A lot of times I will stop it and I'll ask the witness, and I'm not after a question, but after the question and answer, I'll stop it and I say, okay, Juan, what was that question? And they'll look at me and say, can you play it back? I'll do it again, hear the Q&A. Okay, what were they asking you? Because most often a witness is not answering the question that's asked, okay? They're thinking about where the attorney is taking them, what this means, if they mess it up, I got to watch out for this. So I spend some time what I call listening skills. And again, I use the flip chart, and I draw a line. I say Q&A process, and I put A for attorney, and I'll make a squiggly line, and I'll put a question mark, and I'll tell the witness, you know, while the attorney's asking the witness the question, you need to be actively listening. Then I ask them what they think passive listening would be. Well, I said, well, I'll tell you what passive listening is. Passive listening is thinking and listening. You think that you're listening, but you're really thinking, okay? And both of those functions are suffering. So I ask them to be patient until they've heard the door slam on the question mark. And I tell them that that is very beneficial for you for 2 reasons. First of all, it creates a pause. That pause is beneficial to your attorney defending your deposition, because he can do his or her job and say, objection form, okay? And we tell them that, we tell the witnesses that that's probably the only type of objection you're going to hear. You're going to come into the deposition with the mindset that you're there to answer every question unless you hear these magic words. I instruct the witness not to answer, okay? But you know, if you tell them that, look, they got to answer every question that's asked unless they hear that, then they automatically say, well, I can't look to my attorney for an objection. He's not there to save me, okay? So I like to do that Q&A, and I like to, you know, do the video if possible and critique it, and we shut it down. We don't have to watch the whole 15 or 20 minutes critique because that takes too long, but they will get the idea that, okay, maybe they need to listen more closely. When I continue with the listening skill training, I talk about the pause, objection form, but it's also, if that attorney has a problem with the question as it's asked, maybe you should also. That's when you can exercise one of your witness bill of rights. Can you repeat the question? Because you have a right to understand the question before you answer it. It also gets them to ask themselves, can I answer this? Is this in my frame? Do I know it? Did I say it? Did I write it? Did I read it? Is it a meeting? And, you know, it's part of my duties and responsibilities. Can I answer this question of my own personal knowledge? Then it's like a matrix. If it's yes, you're going to answer the question. If it's no, you're going to not answer the question cooperatively. And then you just stop and wait for the next question. Question, answer, question, answer.
Yeah, so this underscores why practice is really important, because there's all kinds of nuances to witness prep. You know, in a deposition, you don't want to give the other side a lot of information. They're looking for information, and you don't want to give it to them. But in trial, it's potentially a different animal. And sometimes you have a witness that can both think and listen, and they're dexterous enough to sort of see where they're going ultimately with this. I would say by and large, most witnesses cannot do that, especially if they're sort of first and second time back witnesses. So all of this Q&A is really important to kind of review, see how they're doing with those things, and come up with strategies to help them. So Stanley touched on, you know, can you repeat the question? Those types of things can be used effectively on the stand for a couple reasons. One, relax the witness a little bit more and buy some time. So if they're feeling a little overwhelmed with the pace that opposing counsel is trying to set, they can take a breather by saying, oh, I'm sorry, I didn't hear the question, or could you repeat that, or I'm not understanding, you know, that question was 2-part, those types of things. Those are both informative and can buy some time and interrupt the pace. If they don't, you know, you don't want them answering something they don't know, like Stanley said, if it's not under their purview, but they're falling into the trap of answering the questions, then they're speculating and guessing, and nobody wants that. So it's okay to say things, I don't remember, or that's not really in my job description. Not very often will I have I see a judge enforce the yes or no. You know, there's all this drama with opposing counsel saying, it's a yes or no question. You have to answer yes or no. The judge will usually say, you know, I'm not going to force each witness into that. So all of these, on the Q&A session, you can come up with strategies to help the witness with either anxiety or knowledge or confidence, as well as some strategic stuff to thwart opposing counsel, if you will.
Right. I forgot to mention that early on when we're just talking about, you know, unmasking, you know, trial testimony or unmasking deposition testimony. Of course, you know, I was fortunate enough a long time ago to be successful with this design. And so I had like 3 or 4 main clients that, you know, every deposition, every witness, fact or expert, I did witness training with. And that's a great, it really cuts down on the sound bites. But one of the things I do with witnesses for deposition testimony is talk about the deposition truth or deposition philosophies. And my number one deposition philosophy, again, I'll use the flip chart and I say the goal of a witness is not to win, okay? The goal of a witness is to maintain the status quo. The goal of a witness is to listen. Listen to the question, think about your answer, give your answer, wait for the next question. Another deposition philosophy that I like to talk about is that less is better, okay? Deposition is designed for the other side to get sound bites, you know, make excerpts of depositions that they can play out of context, out of sequence, you know, and get that sound bite to be meaningful when it shouldn't be meaningful. And so I talk to them about less is better. Less meaning the best answer always is the truthful, concise, complete answer. And when you do your Q&A and then they're rambling, we play that back and I said, okay, Juan, how can you answer that and still say the same thing using less words, not volunteering information, but just answering that one question only. And another deposition philosophy I tell them right away is the camera is the jury, because I want them to understand that their body language, their demeanor, their voice quality means something to people who look at this deposition video. Just like at trial, jurors are making assessments of character and conduct the entire time. So I tell them that the camera is the jury. I don't like them to try to give their answers directly to the camera. It's totally unnatural when somebody's sitting to the left or right of you pretty close. So the only time I recommend that is when I already know that this particular attorney is so sarcastic, aggressive, assertive, overbearing that I can take that attorney out of the role by just getting the question, looking at the camera, and giving my answer. And so those are my kind of deposition philosophies or deposition truths that I like to, you know, talk to the witness about.
Yeah, so as everybody can see, I know we're coming up on our hour. You know, there's a lot to witness prep. There's a lot of nuances. There's a lot of strategies. There's just a lot of technical information. So, you know, if people are interested, I think we could probably do another one of these at some point, more, you know, sort of more advanced kind of tips and tricks. But are there any questions? And of course, you're not limited to today. If something pops up, you can always email one of us.
Yeah. Yeah, I think that if you, go ahead.
Sorry, hey, this is Camby. I have a quick question. I think Stanley mentioned, and if you can elaborate on, when you said that it's a better idea for the attorneys to not cross-examine their witnesses, like, I mean, their own witnesses, like in prep, it's better to have somebody else do that because it hurts the rapport. Is that what you said?
That's exactly true.
I'm just curious.
Yeah, that's exactly
yeah.
true.
Please elaborate, because I'm just curious, but please elaborate.
Here's what happens, okay? I mean, it's just like, I'm no psychologist, but you've seen it a time or two. Jurors, people want to know who this person is, okay? And so if the attorney is taking 2 roles, all of a sudden he's an asshole and then he's a nice guy, okay? Well, which is the real guy? Sometimes they can role play so much and be so harsh that witness thinks, hey, this guy really thinks that I'm going to screw this up. He is pushing me to the limit. And so it's damaging to that relationship, okay? As simple as that. It's just,
and not only that, because they're an advocate for their witness, they really don't hit cross enough. And the witness is taken off guard when deposition comes and the attorney might be a little bit more aggressive or something. So there's sort of 2 reasons to get that person off the cross.
I want somebody else to be the bad guy, can be. I want somebody else to be the jerk, not the attorney that the trust has to be between the, you know, it's not that they can't do it, but they're out of character. So which is the real character, right? That's the reason.
Yeah, that makes sense. Thank you.
What's this might be for the next session, but you started to talk about prepping an expert witness. Where's the corporate, what is it, the 30B6 witness? Where do they fit in between here?
Yeah, they're sort of in between, Dave. Good point. I mean, they usually haven't testified a lot, but they're supposed to be sort of the person most knowledgeable, but they often are just the person most available to sit at trial every day.
Right. And also you can, if they have identified, or if you have a chance to talk to these people about who their 30B6 witness is before they designate it, you can tell them, okay, maybe we should, do some witness preparation or witness training with this witness to determine if they are the right person instead of just tagging them. I had a case.
Like that is a dream. That would, like that. I've never had that happen in 24 years where somebody said, hey, help me figure out a 30B6. I mean, that would be awesome, but that's great. I had
an oxychemical case years ago, and we had 2 candidates for a corporate representative 30B6 witness, and the attorney said, oh, Michelle, she'll be great, but we'll put Ken up there too. So we actually did a witness training, witness preparation with jurors, bring some jurors in, reading them, a basic case background, case summary, and then do examination with each of the witnesses. And so the attorney that they thought, and these were in-house, these were lawyers, okay? And you might think a lawyer would be a great witness. Lawyers can be the worst witnesses. They have their own challenges. And so and this was right before the deposition, a couple of days before, and they said, oh, whoa, man, she is going to be terrible. We got to get Ken up to speed. So, it really makes a difference. But
it does, and it just sort of underscores that we want to be really seen as members of the trial team and get in there early and take them through the end, because then we build trust with the client and they'll allow us to do these things. I mean, clients don't consider us advisors on who the 30B6 is. I mean, they go straight to the client, and the client says, well, we can spare Mary for a couple of weeks and she's pretty smart about the company. And then that's not the way to make that decision.
That's true. But as far as expert witnesses, Dave, I worked in a bad faith insurance case for Zurich years ago in North Carolina. I think I did witness training with 12 or 13 expert witnesses in that case. And 201, they left thanking me. This is going to help me going forward. And I'm talking about expert witnesses who have given bunches of testimony. Just like a fact witness, I can spend some time with an expert witness, look at their CV, look at the number of times that they have written a presentation that they presented 1,000 times. This had to do with mold case, and this expert was a mold expert, and he had like 7,500 hotel rooms that he had looked at mold and blah, blah. So I'm looking at his CV, and I said, well, you've been a busy guy. And he said, what do you mean? I said, gosh, 7,000, and that was in 2 years? So that's like 2. And he looked at me like, okay. So right away, you can tell whether they're full of crap or that they are okay guys. But here's the problem with expert witnesses, Dave. They're necessary. You got to have them. But to a juror, I think we will all vouch for this, is that an expert witness's true value is if that juror can say, that makes sense to me. I could have got that, okay? Expert witnesses often come to the game that, look, my job is there just to give my opinion. Partner. Your job is to make sure that fact finder understands why your opinion is the correct one, okay?
Yeah, experts are a whole nother ball of wax. Go ahead.
So I know we're at the top of the hour, and you probably have a few things on your plate today. First, tremendous thanks to Stanley and Julie. I think that was really valuable for everybody. And I would say, keep in mind that this is one of those things that it's an ongoing seminar, because you can always ask these or whoever who's got this experience and share what we know. So it sounds like we could turn this into 3 sessions if we wanted to. So
if anyone wants to hear a quick war story, I'll tell you what kind of witnesses you can end up with sometime. New York City, 52nd floor of the Grace Building, CEO of a giant corporation who builds window curtain for these high rises, these skyscrapers. He's an engineer from Virginia. My attorney says, I can't do a thing with him. You got to come and help me. 2 days I spent with him. We finally get to talking about attire. And this is a gentleman with he's got a PhD. Anyway, he's got a pale blue shirt on. And I said, well, Carlton, that color shirt would probably be okay at trial if you have a conservative sport code. And so we talked about attire. About half an hour later, he asked to be excused. I thought he was going to the restroom. He comes back in. and he has 2 shirts on hangers. Okay? You would think that somebody might just describe the other shirts to you, and you could say, oh, yeah, yay or nay. One of them was a white shirt. Okay? One of them was a white shirt with a small stripe. And so as soon as he comes in the door, I'm saying, well, yeah, either one of those. Oh, no, wait a minute. He goes into the corner, takes his blue shirt off, puts his white shirt on, buttons it up, sits at the end of the table and says, now what do you think? I'm sitting there biting my lips saying, yeah, I think that'll work, Carlton. And he does the same thing with the 3rd shirt. So don't be surprised what you come up against, okay? Every human being is just stranger than fiction.
Thank you, guys. I really appreciate it. Wish you a good day. And, of course, share questions informally offline, too, as well. Appreciate it.
Thanks, Phil. Bye.
Adios.
Thanks, guys. Bye-bye.